of stay of execution must be made on consideration of exceptional circumstances that can affect the parties, which exceptional circumstances include the wreaking of irreparable harm if an order of stay of execution is not granted. In the ruling of the Supreme Court on 18th October 2024, the Supreme Court was very clear that its orders were being made because of the exceptional circumstances that would flow from the effect of the ruling of the Speaker of Parliament declaring the 4 seats vacant and a determination not to allow the MPs to remain in Parliament. What are some of the effects that weighed on our minds as exceptional circumstances that were alluded to in the ruling? The 4 constituencies of Amenfi Central, Fomena, Aguna West, and Suhum in the Western region, Ashanti region, Central region, and Eastern regions of Parliament are made up of hundreds of thousands of Ghanaians who had queued to elect these members of Parliament to represent their interests in Parliament as their voices. By declaring that their duly elected representatives in Parliament had vacated their seats for acts that were interpreted within the light of Article 97(1)(g) by the Speaker, the Speaker was actually enforcing this interpretation of Article 97(1)(g) against those hundreds of thousands of Ghanaians, and not just the 4 people that sit in Parliament. He was also doing so at a time that from the official records of Parliament presented to the Supreme Court, the Speaker knew that a contrary interpretation was being placed on the same constitutional provision and that the Supreme Court's jurisdiction had been invoked to provide the correct interpretation. By reason of law, there could be no by-election to replace these elected representatives between 17th October 2024 and 7th January 2025. So, 7th January 2025. 2025. So these Ghanaians would have been left without a voice and representation in Parliament from 18th October 2024 until 7th January 2025, when the 9th Parliament can be duly constituted in Ghana. This exceptional circumstance arising from the outcome of the ruling weighed on the mind of the Supreme Court to grant an order directing a stay of execution of the ruling of the Speaker on 17th October 2024. Second, the effect of this ruling would be that the salaries, allowances, and other emoluments of these members of Parliament would have had to stop being paid immediately. They would have had to vacate their offices in Parliament and cease functioning on any committee of Parliament that they were serving on. If any of them was a minister or deputy minister and had been appointed as such by reason of being members of Parliament, the ruling that they had vacated their seats could have brought those duties to an immediate halt. Indeed, one of the 4 members of Parliament is the current second deputy Speaker of Parliament. The Supreme Court was very clear that these outcomes that could cause irreparable harm to the constituencies in issue and the MPs themselves constituted exceptional circumstances to warrant a halt of the ruling of the Speaker until the controversy raised had been resolved.
Right. So that's Her Ladyship, the Chief Justice, Gertrude Araba Isaba Saki Tokono, leading the panel of 5 to deliver their decision as far as the attempt by the Speaker's lawyers to have the decision of the court vacated or set aside. They said, among others, that the claim that they do not have jurisdiction to entertain the current process is misinformation, in their words. They also say that some of the arguments border on an act of disinformation as far as their jurisdiction matters are concerned. Some say that the ruling was not executable. They say you're wrong, it's executable. It was argued that ex parte applications in the ordinary course, we know them to be granted only for 10 days. They said we have power under Article 2 to do beyond that, and we did exactly that. They gave reasons why they gave, even though the people asked for 10 days, they gave an order to last until the case was over. They said if all the parties had complied with their orders to file their statements, the matter would have been dispensed of quickly. Now, we are looking to maybe the 11th of November if the matter will be disposed of. Right after their decision, we had Alan Shermanting issue a statement right after the decision. Among others, Alan Shermanting agrees with Gbagwin in what he did, but says that he should proceed to have Parliament sit and not do anything that will hurt the state further. They said, in light of all the above, they had made some arguments. The Speaker of Parliament is right to declare the 4 seats vacant and issue a consequential order for the minority caucus in Parliament to be considered as majority caucus in Parliament. However, they are thinking that for the general good, they said, with barely 4 weeks to the general elections, it is absolutely critical that all parties, the judiciary, the legislature, the executive, and the Secretary of Ghana, work towards a resolution of the delicate matter to ensure a peaceful path towards 2024 general elections in December. Here in the studio is Andrew Appiah-Dankwa, lawyer and leading member of the Movement for Change. What necessitated the statement that you issued? So we speak to Andrew. We go to Dr. Tony Edu. We have Ni Ama Ade also joining us, and then Kofi Bentel as well. Yes.
Yeah, so let me take this opportunity to wish lovely viewers a good morning. Wish yourself a good morning, and my senior brother here a good morning. I think it's beyond contestation.
I have been enchanted though, the way you get in your yellow, and I saw your campaign in Kumasi.
Yeah.
And long stretch, crowd. Will that translate into votes?
Certainly.
You sure?
I'm telling you.
Okay.
In fact, as we speak, there's a walk, as in what happened in Kumasi is being replicated in Accra, and that's why I'm in my full regalia, my beautiful yellow butterfly.
Let's see how it goes. Now let's hear you.
Yeah, so I think it's beyond contestation that we find ourselves in a very needless constitutional crisis.
Needless?
Yeah, we're very, very needless. Well, that's my personal opinion. Because, you see, for this system of governance we chose upon ourselves, whose focus is to limit powers of government so that the purpose for which we took upon this system, being to protect our lives, our liberties, and our right to pursue our own happiness, can't be guaranteed. It requires a certain level of integrity. And I think what this needless constitutional crisis, in my opinion, is bringing to the fore is the fundamental lack of integrity by people we've granted powers to. Now, why am I saying that? I think the terms of Article 97 1G, which is the reason why we are facing this crisis in the first place, is pretty clear. My personal view is that the framers of the Constitution intended that where you, the MP yourself, you have, as in, done anything under the 97, you yourself should vacate your seat.
Principle of automaticity.
Yeah.
Okay.
In my view, that's unfortunately, the MPs concerned failed to show that integrity and stayed in Parliament, even though, in my view, it's clear that they've breached the terms of Article 97 1G. Also, I think it is also quite clear that where 97, anything under Article 97 happens, is the duty of the Speaker to inform Parliament of the vacancy. I think that's also pretty much clear.
Pursuant to their standing orders.
Exactly.
Okay.
Now, having said that, I think where there's any issue that borders on the interpretation of the Constitution, it's also pretty much clear that the Supreme Court has the authority. We need to understand that our system of governance is premised on the belief that the Constitution is supreme. It's the Constitution that creates powers, constitution that distributes those powers. And in that light, even the Supreme Court themselves are under the powers of the Constitution, as in to say they do not have unfettered powers.
But we must agree that there's a level of supremacy in our representation in Parliament, even though there's supremacy of the Constitution.
Yes.
Since all of us are represented in Parliament, if you are looking at the hierarchy, Parliament will hold supremacy in the philosophical sense of it.
Yes, but the Constitution is
supreme. Yeah, no contest.
You understand? And we also understand that to achieve the purpose of the Constitution, which is to protect our lives, our liberties, and our right to pursue our own happiness, we, the people of Ghana, recognize that to do that, then we needed to separate the powers of government. You understand? And create institutions who are meant to be equal, so that our rights will be guaranteed. Also, we need to understand that the circumstances under which one arm of government can interfere with the other arm of government is clear. So, in this case, under what circumstances can the Supreme Court interfere with how Parliament acts? I think that position is also clear. That where Parliament acts in a manner or uses their powers in a manner which contradicts with the Constitution, or acts outside the scope of the powers the Constitution has granted them, then the Supreme Court and Article 2 can interfere. For me, the issue is whether or not the condition precedent under Article 2, and under which will necessitate the Supreme Court interfering with how parliaments act, has happened. I know they made reference to Article 2. Personally, I disagreed with their interpretation of Article 2. Because if we read Article 2 clearly, there's only circumstance under which the Supreme Court can have the authority to interfere with how parliaments act, and in this case, to stay execution of Parliament, is where they've made a declaration that how Parliament used those powers is unconstitutional. You understand? Clearly, that hasn't happened. The Supreme Court has not made...
Somebody has gone to the Supreme Court.
Yes.
The majority leader has gone to the Supreme Court, and anytime I say majority or minority, it's difficult for me since day one of this parliament, because I don't really think there's majority or minority.
I agree with you.
But the notional sense,
according to what the Supreme Court says,
in the notional sense, there is majority and minority.
The law is the law.
Now, somebody has gone there to complain that there's a meaning being put on 97(1)(g).
Yeah.
He disagrees.
Yeah.
Supreme Court says, we are the ones who have the power to interpret the Constitution. You just said so.
Yeah.
To that extent, our jurisdiction has been what? Invoked.
Yeah, exactly.
So if something is going on, we can make provisional orders. And the provisional order is that the thing you have done, hold on until we finish.
So you are putting an interpretation to Article 2. Does the term of the Article 2 mean that they have the powers to make provisional orders? Because, in fact, what I was hoping, and the Supreme Court is saying, where we disagree, then it calls for interpretation. You think they have? I think otherwise. So, in my view, probably the Supreme Court on Wednesday should have interpreted the Article 2, because they need to meet the condition clearly, which would then give them the powers to make the...
For the benefit of our viewers, listeners, Article 2.1, and they took time, read it over and again. Article 2.1, a person who alleges that an enactment or anything contained in or done under the authority of that or any other enactment or any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect.
Yes, exactly.
Fayemakin went to them and said that Bagwing is doing something. That thing, he's putting a meaning on Article 97(1), which I disagree with. So it's inconsistent with...
Exactly, but the Supreme Court hasn't made a declaration on that. The Supreme Court has not determined whether or not, please, the Supreme Court has not made a declaration as to the meaning of Article 97. Because when you read Article 2.2, the purpose of of the orders is to give effect to their declaration. It was let's read 2:2. It says that the Supreme Court shall, for the purposes of a declaration under clause 1 of this article, make such orders and give such declarations as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made.
They quoted this to support what they did.
And my view is that the terms of Article 2 dictates that before they make any such orders that will interfere with other arms of government, because you see, because of the purpose of the Constitution, interfering in other arms of government is something that should not be, as in, should be done carefully. And that's why, I think that's why the framers of the Constitution had put in place this article. Okay. So that before the Supreme Court can interfere in how Parliament does its business, then it must make a clear declaration as to the set contravention. But when they have not determined that Parliament is acting in a manner outside the scope of their powers, or is acting in a manner that contradicts their powers, then what would be the reasoning or the purpose for interfering with Parliament?
As a matter of law and practice, jurisprudence, is it not right that the courts have inherent jurisdiction in the first place, and they have power to make provisional orders? So they are yet to determine this, but before we determine it, we are saying, hold on. We are not saying you have done wrong. We are not saying Parliament has done wrong yet. You are saying they should have gotten to the conclusion before they can make any orders.
So something, and that's where the other question comes. Because you see, we are under the rule of law, where the law is supposed to be certain. One argument that has been advanced is we all know the circumstances under which you can stay execution, per practice, per procedure. We know. You understand? The Supreme Court and how they state this, have stayed execution, have gone contrary to everything we know. Because per what you are saying, we know the one under which the Supreme Court or the court stay execution.
The point of law, it will help.
After, when I'm done.
No, wait, make your notes. Make your notes. Yeah.
You understand? And the arguments that have been advanced by so many lawyers concerning how the Supreme Court has gone about this day, contrary to what we all know. You understand? And that's why I'm of the view that, you see, they themselves were talking about special circumstances. We are talking about a situation where the Supreme Court is attempting to interfere with how another arm of government is doing its business. I'm saying that per the Constitution, before you can do that, then you must have made a determination that in how they are using those powers, they are contravening the law. They are using those powers in a manner that contradicts the law. Then you can conveniently make those orders. But you have not done that.
The law is in the bosom of the judge.
But that I'm saying that per the concept that says that the Constitution is supreme, their powers are unfettered.
Nothing more pretentious than what the courts will do.
But because you see, we are saying no to dictatorship by the executive. We are saying no to dictatorship by Parliament. We should also say no to dictatorship by the Supreme Court, because
of course there should be judicial accountability.
Exactly, because then at the end the whole concept of constitutional democracy, whose focus is to limit powers of government, and the powers the courts are using are powers of government. You understand? For the purpose of safeguarding our lives, our liberties, and our right to pursue our happy. If we say that because the law is in the bosom of the courts, then they can on that premise interpret or use the law anyhow, then is it not against the purpose of the constitutional democracy we took upon ourselves?
Not exactly that they use it anyhow. I was just going to, bring your attention to the fact that Article 125 says justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. So when they sit there, they are sitting there because all 35 million Ghanaians cannot sit in the Supreme Court. Right.
And let me add that, you see, justice emanates from the
people.
Exactly. And justice is by what? The law. You understand? Justice ought to be
interpreted by
but justice ought to be by the law. You understand? So immediately we think that because we say the law is the bosom of the, so they can propound any law, any theory, which contradicts the Constitution itself.
The preliminary prayer for the recusal of Justice Ernest Jeu do you agree with it that because he has been a parliamentary candidate on the ticket of the NPP, he shouldn't sit on a matter like this?
I agree on all fours with that. Because see, in the Salah case, if you remember, in the Salah as Attorney General, a similar issue arose where they say that because the premise for this are going to be on that it breaches the principle of natural justice. That where you are being a judge in your own cause, and the key question is there a real chance of bias?
Real likelihood
of bias. That's the test. Now we all know that underneath what is going on is a battle between the MPP and the NDC.
The court doesn't see this as that; it sees it as an interpretive issue.
No, it is an interpretive issue, but also because there's a burden, but because of the burden on the judges, not just to give justice, but to manifestly be seen to be giving justice. You understand? And because, and then like you rightly said, justice emanates from the people. You understand? So that if in how you are going to give that justice, which it really is emanating from the people, there is a chance that that justice will lack legitimacy, because in the eyes of the people, because of his having been in the MPP, actually having attempted to stand as MP for the MPP.
Don't you think that would be a bad precedent? And if that happened, are you suggesting that anyone who was ever associated with a political party openly should, if they get onto the court and there is any matter involving the political party, they should stay away?
We have about how many judges? 15 Supreme Court justices, not so. Now, if by just one appointment, it can undermine the legitimacy and integrity of the judgment of the Supreme Court, what do they lose if he recuses himself, or the CJ, who has the power to appoint? Taking into consideration the perception in the system now that Nana Akufo-Addo has deliberately populated the Supreme Court with his people.
Deliberately?
Yeah, that's the perception. I'm not saying that's the perception out there. Don't you think you'll be doing the country a better service if just this one case, this judge will... In fact, I'm disappointed that he himself didn't recuse himself. Yeah, you understand? Because if your focus is to give justice, and we understand when we were in law school, it was something that you kept on saying, that justice must not only be done, it must manifestly be seen to be done. And we know that that perception will not enable that burden of justice being manifestly being seen to be done. It can't meet that burden.
Even the situations of conflict of interest, the law and practice globally is that you must declare. When you make a disclosure, then you have, as it were, disinfected yourself. We already know that this is where he was. So where is the conflict again?
No, I'm talking about...
It's not as if it's secret.
In fact, because it is open, that's one of the reasons why he should recuse himself. Because we are talking about a highly political situation, you understand? And you want what's called a decision which will have legitimacy. And we know legitimacy is about the acceptance of sin. We have 15 justices. Don't you think you'll be doing the country, you understand, a better service if in this matter, which we all know that the undertones has to do with MPP and NDC, this man who is perceived to be with MPP recuse himself?
We'll come to how we proceed from here. The Speaker has issued the summons for Parliament to reconvene. Dr. Toniedu, let's hear from you. We have heard from Kweku Ansah-Sarri, the likes of Kweku Ansah-Sarri, some of their pronouncements. Some lawyers say it's very unfortunate to suggest that, you know, the Supreme Court is just doing the bidding of the NPP. He actually uses the expression that the court has become a sort of a wing of the NPP. Chachuchi Kata, the Venerable Chachuchi Kata, says that the problem of Ghana, the economy, is not even comparable to the problem we have with the Supreme Court. Some say we should be careful not to destroy the only institution that is left to keep our, polity. What do you say? Yes, Dr. Toniedu, I understand we have a little, we have some difficulty with his line, so we'll get to hear his comments. Reading from Dr. Atta Kennedy, a number of the people, the comments Is that the way to approach, even if we have to criticize? You know, the court says that criticism of the court, however rambunctious, is allowed, but it ought to be measured and tempered. Let me hear from Niyama Ade.
Yes, it's very unfortunate. It's very unfortunate. And as one of your slogans plays, we have to see to this country. I mean, like I say elsewhere, we all have a country, and the fair administration of this country is what leads us all to that prosperous future that we look at. But where you have a situation where a section of the people feels that justice is not being delivered fairly, then it becomes a problem. And that is the philosophy of what? Perception. I heard you clearly when you talk about the composition of the justices who heard the matter. That is in Article 1282, that yes, they can be 5. But who are those persons? You see, who are those persons? So that if there is that perception that that person's view or that person's inclusion is likely to dilute the judgment of the court, then something should have been done about it. And it is not a situation that our Supreme Court lacks judges, but we have 15 of them. So if 5 ought to be constituted, and there is the perception that the inclusion of some members of these 5 can raise eyebrow or give the perception that fairness is not delivered, then there is a problem. And I think that is what we are facing now. And that is what many have said, including Ansar Sare, including the Venerable Chachuchi Kata, including many others who have said. So that if the Supreme Court was minded, and they have gone probably, sorry to say, into their intuition, they would have known that the inclusion of this person would have thrown certain, or would have discredited, if you like, the Supreme Court in its judgment. And it is very unfortunate that they did not see it. Okay? But even then, if you go to Article 22, as we said earlier, that a person who alleges that an enactment or anything contained in or done under the authority of that or any other enactment, or B, any act of omission of a person is inconsistent with or in contravention of a provision of this Constitution, may bring an action in the Supreme Court for a declaration to that effect. So it means that any person, okay, so where you have a political matter, what my question here is, what would have been the outcome if it wasn't lawyer Apenyomaki who went to the Supreme Court, but any other person? And in such a political disparity, in such a political divide, as we see, why should it be him and not anybody else? And if it was anybody else, as the Constitution states, what would have been the outcome? Okay, I'm saying this because we are looking at the engineering of our judiciary system, how they work in tandem, or how they work consistently with every step that is being taken, so that this perception that is gone out there would have been avoided. So for me, I would clearly say that yes, as very good as our judiciary is, when it comes to political matters, it is very unfortunate. And it has been so with this administration. I mean, to put it bluntly, It has been so with this
administration. Let's hear Dr. Tony Edu. Hello, Dr. Tony Edu.
Okay.
Samson.
Yes.
Samson, I will not pretend to be a legal practitioner. My knowledge of the law is essentially jurisprudential. And I know that in every society, laws are made not in the belief that everybody will obey the law, but in the hope that very few people will breach the law so that we can manage the legal behavior of people. Secondly, laws are made and principles are applied in a manner that should be predictable from circumstance to circumstance so that potential litigants will know when their behavior will infringe the law and the consequences. The Supreme Court has, over the past years, especially under the Akufo-Addo administration, behaved in a manner as if it is a supranational, supra-constitutional body that can interfere in every act of parliament. Passenger Markin's writ did not show any legal cause for interpretation. All it showed was the consequences of the act of 12 members of parliament, that they will be deprived of their membership and so on and so on. Those are not legal matters. They are the consequences of their actions under a constitutional provision that is as clear, does not require interpretation. The Supreme Court, can it tell us how come a purely political issue get the garb of constitutional issue for interpretation? Interpretation against who? The Speaker applied the law as it is stated in Article 97(1)(gh). Automatic application. The consequences you face is the result of the constitutional provision, not the Speaker's ruling. So why is the Supreme Court acting as a fifth columnist for the MPP party? Every matter that the MPP loses in Parliament, it quickly goes to the Supreme Court because it knows that it's a packed court where decisions will be in its favor. This is not the route to the proper democratic governance of our country.
Is that a fair comment?
Yes, it is a fair comment. Because the facts are clear. Is it a fact that these 4 MPs have breached Article 97(1)(gh? Yes.
The court is yet to decide that.
That is not an interpretive matter. You only interpret where there is a dispute, where there's ambiguity. The Constitution itself makes it clear. So what are you going to interpret? Are you going to interpret when the effects of that provision should take effect? Or are you going to interpret on the basis that their interests are hurt? They should have known that their interests will be hurt. It's a question of their right to be presented. Go to the High Court.
Hello, Dr. Edu?
Samson.
Yes.
Yeah.
Right. But don't you find, for example, the preliminary objection, the manner in which they dismissed it, that it is useful? Otherwise, perhaps there will be a time that everybody will be painted with the brush of MPP or NDC and nobody can do any work at the Supreme Court?
You are talking about the
request
empaneling of
exactly.
Justice Gao.
Yes.
Well, the empaneling of Justice Gao, to me, does not have a stand in equity. because if he has a vested interest, he should have recused himself. But the NDC caucus in Parliament also bear complicity, because you knew the political colors of these people and you approved them in Parliament, including the Chief Justice herself. You raise questions and then you go to the floor and then approve them. So you are also a court against you.
But yes, you began with a caveat that you are no lawyer, but of course, you are deeply philosophical and you, as you said, you appreciate jurisprudential matters. On the substance of the decision of the court, where they say, you know, their powers are being challenged as to how to issue an interim order, the law says it's for 10 days, but we ignore the fact that they can come under Article 2 and do beyond that. And they actually give a good reason and say, after we issued that order, we asked the parties to file their statements within 7 days. The expectation was that if they had complied, we would be getting towards resolving the matter quickly. So 10 days would have been of no moment.
First,
they say these
in a
MPs,
political dispute.
They say these MPs should not be, their constituents should not be denied representation for the next 2 months that Parliament has. Don't you find some good reason and logic in how they come to this?
Samson, where is the reasoning when the Supreme Court is behaving like a topsy-turvy? What happened to the constituents in Aspen North regarding Jachikwesin's case, wherein they are also deprived of representation? What about South, the constituents, the thousands of people in the South who have been denied representation for 4 years? The Supreme Court is not predictable in its application of the law. And I said that does not help our democratic process. Today you stand here, you contradict yourself. Tomorrow you stand there, contradict yourself. Did we set up a supra-constitutional body to terrorize us or to guide our constitutional behavior? It's flip-flopping all the time. The Supreme Court is flip-flopping.
So let's move to Parliament. The Speaker, can you predict his next move? Because there's suggestion that yes, he may have summoned a recall. The MPP cannot marshal half of the members of Parliament to be able to take a decision if they don't have the NDC joining them. So either party cannot do this. So we are likely to see a situation where people appear for the recall and he does what he has done previously.
In which case, what is the use of the Supreme Court's ruling? You call Parliament. It's not only the Speaker involved, the NDC too is involved. They will also make sure that you don't get the quorum for decision taking, a stalemate. What Afenia Markin and the Supreme Court should know is that political matters can be negotiated, not legislated, not subject to constitutional interpretation, where there is no grounds for constitutional interpretation. Afenia Markin can still get government business going if he comes down from his high horse. So you sit in the minority side, so what? You negotiate for government business to continue. But now you create a situation, an antagonistic situation, where the NDC too says that we will deny you the quorum to take decisions. Then where does it stand? Where does the whole matter stand?
What ought to be done in the name of peace and progress as we go into the elections and want to see that things are peacefully done? What ought to be done?
The MPP caucus must come down from their high horse and negotiate with the NDC caucus.
Okay.
Take the Supreme Court out of it. It is interfering. It is interfering negatively.
Okay. Kofi, there are those who say, like he began, you know, that even the matter of the interpretive jurisdiction of the Supreme Court is an issue that ought to be determined by the court. So the court cannot make the determination without hearing the matter. And the court has done so upfront.
It's his view, and I disagree. It depends on how the matter comes. And if you read Article 2.2, there's a future tense there. It says, as it may consider appropriate for giving effect, that is immediate, or enabling effect to be given, that is future tense.
To what?
To the declaration so made.
Which declaration?
So I'm coming.
He's telling you the declaration comes after you have finished the case.
I hear you. I'm developing my point. No, wait. Listen to the Supreme Court's own reasoning.
Right.
They are faced with an ex parte.
And please, I don't say I share his view.
Of course, I understand.
Because when I play the devil's advocate, 2 minutes and people confuse it with an opinion.
You see, this thing...
I'm ready to take opinions, alternatives. Thank you.
I wish we didn't have to debate it outside.
Right.
Because really, when sometimes people behave as if there's an answer and they know it, I think it's not really the best.
The problems of
things
confirmation bias.
Yeah, you know, simple things, it's important. Simple things like the fact that all men were born equal. A war was fought over it in the US. Okay? And before they got a Magna Carta, to get kings to appreciate that all men were equal, they had to fight a war. So now we take it for granted that these things...
Back to Article 2.
So back to the point. Here's the thing. You are the Supreme Court. There are a number of things that we all should agree on, and we'll proceed from there, because those ones are not controversial. Number one is that the Constitution is supreme above everybody and every institution. We agree.
Correct.
Two, the Supreme Court is the only body that may interpret the Constitution. We agree.
We agree.
Correct. So whenever there is an issue that has to do with the interpretation of the Constitution, the Supreme Court takes precedence. Now, they are then faced with a situation where somebody comes ex parte, which means they come alone without the other party.
They come on the blind side of the other party.
However, I'm speaking to the general public, alone without the other party. So the other party cannot make their case before the Supreme Court. We all know that when that happens, what the Supreme Court or any court does is they listen to you and they will judge whether the situation is so exigent that they must make some sort of interim order.
Interim.
And the rule says the order should be up to 10 days. Note, I'm speaking as to what the Supreme Court was facing. Now, then make an order and say, we are giving you 7 days to come back. And the other people should also come back and file their papers so we will hear their side. It's within 10 days. Now, the Constitution gives them power that in terms of making those orders regarding these matters, they should be able to make all orders that help them to make a declaration and, you know, follow through to make sure that the proper thing is done. Which is why they were telling you that they have the right not to say 10 days, but then they have given you 7 days, and if you obey it, you will come and they will deal with it within 10 days. Look at the other side. What if they chose not to come? Okay? Then you realize that
not to come.
If Parliament chooses not to come, okay, or disrespects the Supreme Court, then you realize that it doesn't even matter whether you give them 10 days or not, it won't happen. You must know that they are not called Supreme Court for nothing. And they don't only rule on strict law. There are policy issues and all kinds of things. One of the things we must also appreciate is this. If you disagree with a court, especially the Supreme Court, whoever you are, you must respect their ruling, give effect to it, and then go back to them.
Has anybody disrespected their ruling?
I am making a general point, which you agree with, right?
No, it's part of the thing out there in the
I made the point first. Can we agree?
Has Parliament disrespected it?
I'm not answering your question. I'm saying, can we agree that even if you disagree with a court, You must give effect to their ruling and go back to them.
I've repeated that many times here.
Thank you very much.
Ex parte affoda.
So if you're asking me whether
even
Parliament,
if the decision is wrong,
yes,
even if it's unlawful, if it's unconstitutional,
yes,
you must obey until you have set it aside.
Thank you. So the proper thing should be that Parliament should have given effect to that ruling and then gone back.
Has Parliament failed to give effect to the ruling?
Has Parliament given effect to the ruling?
You answer my question.
No.
Has Parliament failed to give effect to the ruling?
Has Parliament given effect to the ruling? No. You are asking whether that's...
What does it mean to give effect to the ruling?
To positively act to implement it.
How?
You make a declaration that some people have vacated their seats and therefore do not belong in Parliament more or less anymore.
The declaration has been suspended.
So you make a declaration to reverse it.
Really?
And no, wait. Like I'm saying, we are speaking to the general public. Today, as we speak, we know a declaration has been made by the Speaker, and he is the Speaker. Once he makes a declaration in Parliament, it is law. So, to the extent that the Supreme Court has said, per the Constitution, I want to hear you. So, in the meantime, suspend this thing because it has grievous, significance. You should reverse that thing.
Really?
Hold on. Just hear me. You should revert to the status quo.
How does the status quo revert? They say the decision is suspended. It means the 4 MPs are entitled to go to Parliament.
I hear you.
It means the 4 MPs are entitled to sit in the House and vote.
Correct.
It means the Speaker or no other person in Parliament must try to prevent them from entering or doing their work.
Correct.
Have they done any of these things?
So here's my answer to it. You are saying, therefore, that when the Speaker has made a declaration to the hearing of the whole country,
and it has been suspended.
Can I finish? And the Supreme Court has suspended it. It should be taken by everybody, including the Speaker, that the declaration that he made is withdrawn, and therefore the status quo ante is back. That is what you are saying.
It's not withdrawn, it's suspended.
It's suspended, and so the status quo ante is back. They are all parliamentarians.
That is so.
I am simply saying that, you see, what you are saying is what will lead to confrontation, because somebody will sit in Parliament and say, having heard the Speaker say that it is no longer
That is the person who would have breached the court's orders, correct?
Yes, but hold on, Samson, listen. So I'm saying, in respect, or with respect to all these principles that the Supreme Court interprets the Constitution and says this and this, the Speaker should say, having heard them, please, the status quo is back. Then we are clear. Then nobody goes to do anything funny. Then, when the Speaker, is the Speaker of Parliament, sends his application into Parliament, even the tone of the application, the nature of the words, how they are put, will give an indication whether you are respecting or you accept the ruling or not. And you and I, we've made appeals and reviews. Even though you don't agree with them, you give the impression that I am respectful of your order, however, these are my views. I sincerely believe.
In appeals?
Yes. You can absolutely disagree with them and say these are my views.
And that's what you do.
But you don't give an impression that I don't respect your view, and I'm not going to give effect to it. Please change it.
That's what you do when you challenge a decision of the court.
Then you are not getting what I'm saying. What I'm saying is when you are challenging the court, you are saying
when you are challenging a court's decision, you actually say that the court is wrong. Yeah. So what is wrong with them saying that before the court?
I don't respect is different from I disagree. I'm saying the tone.
If you don't disagree, how do you proceed?
You're not getting me. I'm saying we all respect and give effect to even rulings we disagree with.
The tone of the application was problematic?
You are not hearing me or you are not listening to me.
That's what you're saying. The tone of the application was problematic.
I am making some points, and the points I'm making is
that you were wrong. The law we know is that if it is ex parte, it must be for only 10 days. Then they come and say, that's not what we are doing. This is the other way we are going around it. Say you are wrong. You said we didn't give a hearing to the MPs. You also didn't give us a hearing, and you went ahead and made the order. What's wrong in that language?
I am simply saying, as we speak today, there is no express indication that Parliament has effected the ruling of the Supreme Court.
Must there be anything to show that they are effecting the respect of the Supreme Court? Why?
Why not?
When you do
when the Supreme Court gives you an order, when you have given instructions that have an effect,
in practical terms, in your practice, when something has happened and some aggrieved party goes to stay execution of what you have done, do you do something to undo anything?
Until you stay it.
No, do you do something to undo something?
There are times you have to.
You don't.
There are times you have to.
When they stay execution, you just
something.
It has been
There are
stayed,
times
so you sit back.
when you are injuncted or when there are rulings made against you, you have to take actions in pursuance of them.
Really?
Yes, there are times. My point is this: you are saying
You are doing something. When you are injuncted to
You're not
stop,
letting
you
me develop
simply
my
stop. Is that not it?
so. Simply stop. There are omissions and commissions. What I'm saying is this. You are saying that they should go to parliament and exercise their rights as parliamentarians, and until somebody stops them, then no evil has been done. And I'm saying that you don't wait for somebody to go to parliament to try and act as a parliamentarian representing their people, for somebody to stop them. You have seen the belligerence in parliament and how people have said that they were going to defend their majorities
If you
properly.
say, if you say that, I need just a little.
You have been told that some people say they will resist this thing. You want them to resist it in parliament where we have seen fights before. What stops the speaker from giving the signal that having received this instruction from the Supreme Court, the status quo is held as it is? Meanwhile, you hear all kinds of things being said about how the speaker does not accept what has been said.
How do you hear it? Why don't you want to hear the speaker when he speaks to you
I
publicly?
want to hear the speaker
when he speaks in parliament.
Communicate his acceptance
When
communicate the fact that he does not agree. I
the
think it's
speaker,
necessary.
the speaker, when he did the adjournment, what did he say? He said that he has become aware of, he's been served with this process, correct? That's what he said.
He refused the service.
No, he didn't. That's before. That's before his ruling. Not after his ruling. When they came back, when they reconvened, the day that the MPP refused to go to the House because the NDC were sitting at the majority side, he said that this has been brought to him. And that the NDC was the only group in Parliament. That group had the 92 threshold that you can do at business, but they didn't have half that you can take a decision. So he adjourned. He didn't adjourn because he's disrespecting Supreme Court. Is that not correct?
Okay. I'm also making the point that at the earliest opportunity, I believe what would inure to the peace and calmness within our leadership would have been for the speaker to say, I disagree with the Supreme Court, but I have received this order from them. And therefore, that order that I gave, vacating those seats, is suspended. And I'm saying he hasn't done that.
But it's suspended. He doesn't have to say it.
No, you keep saying he doesn't have to say it. And I keep saying I think he has to say it. And my reason for saying so is that I have heard people belligerently, even some angrily, saying they will defend their newly won majority. I have heard, we have all heard, people say they are going to use their majority to repeal laws.
Yeah, they have said so.
They have said so many things that they are going to proceed to do. Not once, not twice, not three times. And you think under those circumstances, we should assume that they are going to go in and do everything properly, okay? And you want there to be a scaffold, somebody stopping somebody physically or otherwise, before they go to the same Supreme Court again for rulings. When you have a state in this situation, that's why I said there are things we agree on. One of the things we agree on is that you can choose to disagree with the Supreme Court.
Why should the speaker announce a reversal when the case has not been heard to determine that he's wrong? Because the court has not made that determination.
Because he has been injuncted per the ex parte ruling that was given. And the ex parte ruling that was given, like you're saying, they should have ruled then. If they are ruled, then you will sit here and say without hearing the other side, they pass. No, hold on. Okay, you didn't say. Sorry, I withdraw it. I'm saying some people are saying they should have ruled on the ex parte.
Okay.
My point is, an ex parte is a one-sided motion. The Supreme Court says the other side, come and let me hear you before I rule.
Okay.
And until then, keep the status quo as it is. And I'm saying the simple thing that would have been done for everything to cool down would be for the speaker to say, I disagree with you. But because you are the one that interpret the Constitution, and even people were saying that this is not an interpretation issue.
So as far as you are concerned, the speaker is a problem.
As far as I'm concerned, I think the speaker has not done what I believe would have led to greater peace.
Greater peace.
Yes.
Okay, so we'll be right back. All right, so guys, You don't look at it that way. I just do what I have to do.
I wish we were doing this off air. Then we'll get through it.
Yeah. So you know that the Habitat Fair is ongoing presently, and you are all invited to be at the Accra International Conference Center. Get a house, make it a home, and there are several other things that you can get, and the Habitat Fair is still ongoing. I've got some messages from you. Let me share quickly, and we're supposed to take a quick break, do we? This one says that I like the way you are interrogating Kofi. We can all diplomatically correct the blunder with bringing the Supreme Court or Parliament down, but insisting on both sides to respect the Constitution, procedures and consistency needed for justice to be seen. This is why are they not questioning the act and intent of the act of the Speaker, which has gotten us where we are? Should the Speaker be left on the loose to do all and everything at his whim? Was the Speaker's action not intended to achieve a political purpose? Right, so those questions continue to be asked, and people ask, what did Michael Okoye do? How different is that? This one says the constitutional duty is rather on the MPs to vacate the seats. No one needs to vacate them. Did the CJ or anyone else have any evidence that these 4 MPs haven't already vacated their seats? Have these MPs occupied their seats since they allegedly put themselves in the prohibited situations?
You should give me 1 minute to deal with that.
This one says that what Kofi Bentil is trying to say is that the Speaker, having acknowledged receipt of the decision of the Supreme Court on the floor of Parliament on the day he adjourned, should have informed parliamentarians that by virtue of the decision of the Supreme Court decision, the 4 MPs affected are to resume their duties. Okay, thanks for that. I'll take a very final message because my production is just pushing me to end here, because that is where
you need to give me a minute
I can end. This one says, when the Supreme Court asserts that it has authority to extend the stay in an ex parte application beyond the standard 10 days, one must question the legal foundation of such authority. Likewise, when the court claims it has jurisdiction over a matter, it is necessary to identify the source of this jurisdiction. The Supreme Court jurisdiction should only be engaged upon the filing of writs concerning determination that contravene the law. At the time of Afenyo King's filing, had the Speaker issued any rulings? Okay, so that was a no, and that's what some disagree with. Unfortunately, my production tells me that our time is up and we have to end here. How abrupt, but thank you very much. It's been Newsfile.